Last video, we covered Section 1 of Ontario's Residential Tenancies Act, the four purposes of the law, and why the word balance matters for both sides. Today, we're diving straight into Section 2. And this is where most landlord and tenant disputes actually begin, because Section 2 is where the law defines its words. In law, definitions are everything. Get them wrong and you could be filing at the wrong board, fighting for rights you don't have, or completely missing out on the legal protections you do have. Think you don't have a legal lease just because you didn't sign a piece of paper? Ontario law says otherwise. Let's start with the phrase tenancy agreement. Most people assume this strictly means a signed written lease, but Section 2, subsection 1 of the RTA defines it as a written, oral, or implied agreement between a landlord and a tenant for occupancy of a rental unit, and it even includes a license to occupy. That means if a landlord has been accepting rent and someone has been living there, even if it was just a handshake or a text message, the Landlord and Tenant Board can legally recognize a binding tenancy. But here's the balance. That does not mean landlords can just skip the paperwork. Ontario's standard written lease has been mandatory for most residential tenancies since 2018. So, while oral agreements are legally valid to protect a tenant, written standard leases are still legally required for landlords to issue. If you are living with a roommate in Ontario, you need to know this Landlord and Tenant Board rule immediately, or you could end up locked out with zero legal protection. Let's look at the word tenant. Section 2, 1, defines a tenant as a person who pays rent in return for the right to occupy a rental unit. But just because you live in a unit does not automatically make you a tenant under the law. The RTA recognizes completely different categories here, and each has entirely different rights. First, you have a tenant. A tenant has a direct agreement with the landlord, is named on the lease, and gets full RTA protection. Second, you have an occupant. An occupant lives in the unit alongside the tenant, like a partner, family member, or roommate, but has no direct legal contract with the landlord. The LTB's own interpretation guideline 21 is crystal clear. Occupants are not protected under the RTA and cannot file applications at the board. Third, you have a subtenant. A subtenant legally rents from the tenant directly, with the landlord's written permission, while the original tenant is temporarily away. Why does this matter? If a dispute comes up and you are classified as an occupant rather than a tenant, the LTB can't help for lack of jurisdiction. You would have to sue in civil small claims court instead. Who is your actual landlord? If you think it's only the person who owns the deed to the house, Ontario courts have a massive surprise for you. The definition of a landlord under Section 2, 1 of the RTA, is way broader than most people realize. It obviously includes the owner of the rental unit, but it also includes any person who is entitled to possession of the property and who attempts to enforce any of the rights of a landlord, including the right to collect rent. In fact, the Ontario Court of Appeal confirmed this in a landmark case called Slapsis v. Abrams. They ruled that there can actually be more than one landlord at the exact same time. This means property management companies, corporate agents, and even a landlord's spouse or family member acting on their behalf carry the exact same legal responsibilities and liabilities under the Act as the actual property owner. Does the Ontario Landlord and Tenant Board protect you if you only rent a single room or a mobile home site? Let's look at the law. The RTA defines a rental unit as any living accommodation used or intended for use as rented residential premises. And this umbrella is incredibly wide. It covers standard apartments and houses, but it explicitly includes a single room in a rooming, boarding, or lodging house, a plot of land or site intended for a mobile home, and units inside care homes or retirement residences. Knowing whether your space qualifies as a rental unit under this definition changes everything. Because if it doesn't meet these criteria, like if you share a kitchen or bathroom with the actual owner of the house, the RTA doesn't apply to you, and the LTB can't help you. So before any legal dispute goes anywhere, two fundamental questions have to be answered first. 1. Does the RTA actually apply to this specific living arrangement? And 2, who is the actual legal tenant? because those two answers dictate everything else: your rights, where you are allowed to file, and what legal remedies exist for you. Next, we are covering Section 3, how the RTA interacts with other laws. Did you know that the Ontario Human Rights Code actually overrides the RTA in certain situations? That is a massive deal for both sides. Follow along so you don't miss the next breakdown.
This video is for educational purposes only and does not constitute legal advice. Laws can change. Always verify current information at ontario.ca and consult a licensed paralegal or lawyer for your specific situation.